Soundstripe.
So the next subject that I'd like to clarify for you is a question that comes up frequently. There's a difference between procedures and processes within the legal world. There's trials to just judges, there's trials to juries. There are also two distinctions. One is called arbitration, the other one is called mediation. And I just want you to be clear on what they involve. Okay? So let me illustrate them just as kind of different entities, because that's the way I see them. Let's talk about arbitration. Arbitration is where a case, including all the evidence and the parties, appear in front of a person or a panel. Could be 3 panel members or just a single arbitrator. And those arbitrators, or that arbitrator, depending on the panel size, is making decisions like a judge. So it's a person who's making decisions based on the facts. They're listening to the evidence, they're reviewing the documents, and they're making a decision. Now, some arbitrators have broad authority. Some different settings for arbitration, like mandatory arbitration in different counties in Washington State, have more limited authority. And then sometimes the arbitrations are not subject to appeal, and sometimes the arbitrations can be appealed. So it's got a different setting in different environments. But essentially, the thing to know about arbitration is there's a judge or a panel that's deciding the case. They're making decisions on the case. And that's the biggest difference from mediation, okay? So if this is arbitration, think about it as there's a judgment being made based on the facts. And the facts are witnesses, documents, etc. Mediation is basically a settlement process. It's a discussion with a mediator in the middle. So the parties agree to a mediator, and the mediator doesn't make any decisions at all. None. Zero. They can look at witness statements, they can look at documents, but they don't decide anything. What they do is just they facilitate negotiations. They go back and forth between the parties, and the parties are normally in separate rooms. Separate conference rooms, for example, typically, and the mediator will go meet the injured party and their counsel, and then the mediator will go to the defense side and meet with the claims department or defense counsel, and then the mediator will go back and forth, and back and forth. Right? But the mediator makes no decisions. Mediations are required in King County. Right? It's part of the case schedule. It's part of the case schedule that judges impose when you file a lawsuit on a personal injury claim. So think of this as just a difference between the worlds, right? One is judgmental, subject to different conditions and appeals. The other one is not judgmental at all. It's just to facilitate resolution and discussion. And you can walk away from the mediation with no settlement, or you can resolve the claim during the settlement discussions with a qualified mediator. Hope that helps.
Soundstripe.